Same-sex marriage judgment, the majority opinion. No right to marriage, no right to civil union can only be through law. No right to adopt children. Have right to choose own partner. Transgender persons have a right to marry. Same-sex marriage judgment, minority opinion. No right to marriage. Have right to civil union. Have right to adopt children. Transgender persons have right to marry. Unanimous verdict. No right to marry. The Supreme Court takes conservative stand on sound legal view.
There is no universal conception of the institution of marriage. It lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. The court, in the exercise of the power of judicial review, must steer clear of matters, particularly those impinging on policy, which fall within the legislative domain.
Did the top court follow letter of law and not spirit of law? Has the top court missed a historic opportunity? Top focus on To The Point this evening.
Good evening, you're watching To The Point. I'm Preeti Choudhry. So the question that we're debating this evening, did the topmost court of the country, the Supreme Court, miss a historic opportunity? Well, it was one of the most awaited of judgments of the year. The Supreme Court's 5-judge bench, mind you, it was a constitutional bench which gave the verdict today, so that makes it all the more difficult to overturn this particular verdict. It was led by Chief Justice of India, D.Y. Chandrachud, and the constitutional bench today refused to grant legal recognition for queer marriages in India. The bench, however, directed the government to form a panel to examine the rights and entitlements of people involved in queer union. Somewhere down the line, could the court have taken a more progressive stand? Did they take a conservative stand, or they just followed the letter of law, missing a historic opportunity? Take a look.
The Supreme Court of India has stopped well short of granting marriage rights to same-sex couple. In a unanimous verdict, a 5-judge bench headed by Chief Justice D.Y. Chandrachud ruled that the law doesn't allow same-sex marriage.
The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law.
The top court, while pronouncing the judgment, said it was not possible for the court to frame a law on the issue, can only interpret existing laws. The bench, comprising Justices Chandrachud, S.K. Kaul, Ravindra Bhatt, Hema Kohli and P.S. Narasimha, in the 3-2 majority verdict, decided against allowing civil unions for same-sex couples. The court also declined to allow adoption rights for same-sex couples. The judges said a committee may be formed to look into the concerns of the same-sex couples.
They've all taken the same position on the question of whether the Special Marriage Act can be interfered with and can it be struck down as unconstitutional, whether certain provisions can be struck down as unconstitutional. On that, the bench has agreed that it is for the legislature to look into this particular issue. It's for the parliament to look into this issue.
The verdict is a big blow to same-sex couples who were hoping for at least civil union rights.
आज का जो वर्डिक्ट सुप्रीम कोर्ट का था उसके ऊपर हम लोगों का बहुत उम्मीद था, लेकिन आई थिंक इट हैज बीन वेरी वेरी डिसअपॉइंटिंग। पार्लियामेंट के ऊपर ये छोड़ दिया है जो बहुत ही डिसअपॉइंटिंग है। गवर्नमेंट जो डिसीजन लेता है वो मोस्टली वो ह्यूमन राइट्स के ऊपर, जो सही जो गलत उसके ऊपर नहीं होता है। उनकी विचार होता है कि किससे ज्यादा वोट मिले, क्या पॉपुलिस्ट है।
With the Supreme Court ruling against same-sex marriage, the LGBT community will pin their hopes on Parliament passing a law that accommodates them.
The LGBT community is saying that while this is a recognition of their rights and of their existence, it is going to be a long fight ahead to actually get the rights of marriage and the rights that come from the institution of marriage in India. In New Delhi, with cameraman Ridul, This is Anisha Mathur for India Today.
Well, what's really happened is that the petitioners in this case deeply disappointed, especially in the kind of language that the judge, the constitutional bench used. It seemed it's going to be a very progressive verdict. But many would suggest that ultimately it came down to the letter of law, and that is what the court followed. Let's break it down. Let's cut across right now immediately. Joining me in the studio is my colleague Anisha. She was there in court today. What was a red letter day, Anisha, but at least the petitioners deeply disappointed. There is a sense of despondency which seems to emanate from the fact that this was a missed opportunity.
Well, definitely, Preeti. We've been speaking to the lawyers, we've been speaking to the petitioners. All of them are saying that, well, we were hoping that the court will go a little bit further than it did, especially with the minority verdict of the Chief Justice and Justice Kaul, talking about civil unions at least being given some sort of recognition in the country. That is where the hopes had been pinned, that something like that could be created. But even in that, we need to remember that the court has said that even if we do give recognition to something on the lines of a civil union, the actual rights, the actual regulations that the petitioners want a change in is something that will require legislative work to be done, because this will require change in multiple laws. But on a more hopeful note, the issue that the petitioners are also saying is that at least this conversation is happening. At least there is a recognition that we not only exist, but we deserve and we have fundamental rights of dignity, privacy, choice. And that is something, at least one step has been taken towards recognition.
Let's quickly bring in the petitioners, because they've been fighting the good fight for years now. Joining me is Harish Sher, petitioner. He was a petitioner today, disappointed, I understand. Hemant Patel, petitioner, disappointed. Hemant, I want to begin with you. It's been a long, drawn-out battle where the fight for equal rights is concerned, especially when it came down to equality in marriage. What do you make of the judgment today, especially the kind of conversation that happened earlier in terms of what the Chief Justice of India said? But ultimately, do you only look at the fine print, which said not allowed?
Thank you. I think I'm going to just say something which might sound very harsh, but that is the truth and the reality. A lot of words were used, but very little meaning came out of those words. Very insightful, very wise words, but they are like wise words in an old book. My personal viewpoint is that the Supreme Court abdicated its responsibility towards the LGBTIQ community, although we do see some wins for the trans community and in some way an executive committee looking at some rights within the institutional framework of a partnership or a union. But again, that's subject to how the government is going to play it out. What is the time frame? What is the duration that would be required to set up something like this? But to be very frank, I just feel that here was this momentous occasion in the history of time to backroll any of the negativity that was thrown towards the community. And as someone who's been involved both in the Nalsa judgment as well as in the marriage equality case, I felt that this opportunity was lost. However, I'm not one of those who will get bogged down by this. My community is known to be strong and resilient. We will fight back. We will ensure whatever gains we made, there will be a larger outlay of this.
Hemant, I'm going to just come in for a minute, and the reason I'm doing so is because I know a lot of you are deeply disappointed. So many of our guests, you were going to have a lot of petitioners today. They're crushed, devastated in terms of what has happened today. But I want to ask you, looking at where the law stands, what did you think that the courts could have done better in terms of interpreting the law?
See, the only thing that I really expected today, without being too frivolous or too over-expectant about the court, was the fact that a clear roadway towards civil unions would have come true. I was expecting that as a minimum guarantee, considering the months of effort put by all of us in arguing our case. That was a real-time disappointment because that framework is absolutely absent in any of the directions given by the Supreme Court in their 300-odd page order.
Right. Okay. Harish Sher, At least, some would suggest a conversation has started where you talk about not just what a marriage means, but the modalities that go into the marriage where rights of spouses come into question.
I think the conversation has moved ahead. The conversation has been moving ahead, and the conversation is moving not because of anything else, but because of the LGBTQI plus community by itself. I think, as Zainab rightly said, the court could have. This was a momentous occasion where the court could have, all the wrongs that have been happening with the LGBTQI plus community. This was an opportunity to correct all of that, to at least provide a pathway to some kind of legalization where if my partner was dying in a hospital bed, I would be given some rights, at least guaranteed by law, that I could take decisions for them. I think this was a moment where we could have done really well. And again, it might sound really harsh, but all it was all a play of beautiful words strung together in strings of hope. But we are tired of hope. We just don't want to keep hoping. We want to start hopping into a new future, start hopping into a world where our rights and our love is recognized. For now, we just have the right to have consensual sex with our partners in private. We hardly have got any other right in this country, but we are not going to be tired. We are not going to be bogged down. We are going to fight this out, and we are going to not rest until we have absolute and equal rights as our heterosexual cisgender counterparts.
We do apologize somewhere down the line because, we understand your pain, and it is a long, protracted legal battle which lies ahead, especially, Anisha, where I bring you in. This is it's a constitutional bench. To overturn something like this is difficult, but how do you see it once again come into the purview of law? Because from here on, the court has said that a committee needs to be formed, that it's in the ambit of the parliament. But we all know, cutting across party lines, no party will actually come out and back equal rights, especially when it comes down to marriage. We've seen how the centre has reacted, where at one level they actually called homosexuality an urban concept.
Well, see, the unfortunate reality of the world and the country that we live in is that a lot moves only when there is a vote bank or a pressure group or some sort of benefit to a political party involved. And that is the unfortunate reality we live in. What I'm looking at this, however, and hope springs eternal, as they say, at least the idea that there must be protection accorded to these relationships, at least that has now come out in a Supreme Court verdict. Yes, the problem here is that there is no timeline. The problem here is that we don't know when, if, how it will happen. But at least it has become a part of a general conversation. At least there is a Supreme Court verdict saying you must do this. So now
But but it falls short, Anisha, because, let's look at it. Were we expecting the court to give, rights where marriage was concerned to the LGBTQIA plus community? Not quite, because they could have said it's in the ambit of law. What could the court have done? They could have, at least where it came down to civil union, they could have, made more changes in that, or, stressed on that more, and at least give a time frame to the committee that they've asked the government to form. Hitesh Jain, I'll bring you in. Advocate, Supreme Court lawyer, is also with us. How do you look at the ruling? All right, we don't have Hitesh Jain, but, Anisha, if you'd want to take that question.
See, speaking about the law and the legal provisions, yes, the court could have done more. What the minority judgment has said, for example, with respect to civil unions and the right to enter into a civil union, that could have been done. But then again comes the question of the letter of the law, and that is where this entire debate of what can the Supreme Court really have done, that is where it sort of hinges, that could the Supreme Court have redefined what husband and wife means? Could they not have created a new relationship of a civil union? Could they not have at least said, well, this exists, so you must recognize it?
Zainab, is that why you feel let down? Because at least when it came down to civil union, it was the rights that you were looking at, maybe not the sanctity of it, or at least right now not the sanctity of it. Zainab, that's questions for you. Harish, can you take that question? I don't think Zainab can hear me.
I think what we were looking for is a passage to the right towards civil unions. I mean, in the sense, what is marriage? If you remove if you look at the Hindu Marriage Act, the Muslim Marriage Act, you look at all the marriage acts, it's basically a legal contract between two people. Even if there was a pathway to a legal contract, where there's some sort of legal recognition to a relationship, call it civil union, call it whatever, whatever good word that we could choose for it. But if there was some sort of a legal contract, pathway to a legal contract between two people that they could get into, it would have been beautiful. Because what really are we fighting for? We are really fighting for not just the right to sing "Hum Aapke Hain Kaun," have "Hum Aapke Hain Kaun" kind of weddings. That's not the right that we are fighting for. We are already having "Hum Aapke Hain Kaun" type weddings. LGBT people are having those weddings. We are asking for legal recognition of those relationships. So if there was a pathway, some sort of a pathway towards the legal recognition. And seriously, the other thing that I also wanted to stress on is the Supreme Court has done exactly what the Navdeep Singh Johar judgment, the directive to the government was that you need to create more awareness, you need to ensure that there's less prejudice. Those were the same directives that were given to the government. There's the same history repeating itself. You're just giving directives over directives, but not having any. There is no timeline to it. There is no plan to it.
Right. Harish, stay with me. I want to bring in Hitesh Jain into this conversation, Advocate Supreme Court. Hitesh Jain, you said you call this the verdict historic. Why so? Because especially where the petitioners are concerned, they're deeply disappointed because we were standing at the cusp of history and we just didn't take that leap.
Well, I don't think you have to look at this judgment only from the lens as to who has got what and who is not getting anything. First thing, as far as the doctrine of separation of powers is concerned, I think we have made a progress where the Supreme Court has said that in a strict sense, we do not follow the doctrine of separation of powers, but we recognize the essential functions of one arm of the state. And as far as the essential functions doctrine, which was introduced today by the Supreme Court has clearly stated that one arm of the state will not encroach upon the essential function of another arm. Second, this judgment also, we have seen, one can see and a progress has been made. This case was not about for or against case for the LGBT. As far as the government of the day is concerned, the government clearly recognized the rights and acknowledged the rights that flowed, as the earlier speaker was mentioning, that was given by the Supreme Court in the Navdeep Singh. The government has acknowledged the right. The only question that was pending before the court, and which is the most important question, whether the Supreme Court can grant such rights or such rights have to be granted by the legislature. As far as the right to queer is concerned, it is a very important recognition the Supreme Court has given, and unanimously all the 5 judges have recognized the rights of queer, the rights that they are entitled, basic domestic rights, basic fundamental rights have been acknowledged and have been respected. The only thing what the Supreme Court has done today is they are saying that as far as all the other rights are concerned, it does not come within our domain. You have to go to the parliament. The parliament is the right and the appropriate forum. And therefore, it is the parliament which is the important stakeholder. The Supreme Court has also taken on record about the suggestion that was made by the government of the day when the Solicitor General made a statement that a committee headed by a cabinet secretary will be appointed, which will look into all the issues and then take a proper informed decision. So I think we have made a progress. It's and therefore I say this is a historic verdict.
But, the petitioners don't see it as historic. But let me bring in Karuna Nandi into this conversation. Karuna Nandi, where did we fall short, where the Supreme Court ruling today was concerned? The petitioners were hoping history would be made, but having said that, if the top court hadn't touched the issue of marriage, could they have done more on civil union?
What we were hoping, and we were hoping for at the very least, was a declaration that there is a constitutional right for queer people to be married, and for then that to be taken forward in future decisions or in future legislations. Now, two judges have made that finding. They have not said that there is a fundamental right to marry, but they have said that there are particular aspects of marriage that find themselves rooted in Article 21, in Article 19, and for example, the Article 14 analysis of the CARA guidelines with regard to the ability and the right of queer parents to adopt as a couple is rooted in Article 14, and there is a very robust analysis of that. So, and I encourage law students and lawyers to look at that, and indeed I encourage the government to look at that, because the object of when two of the most senior judges of the Supreme Court say that there is nothing to show that queer parents are not as loving and that as heterosexual parents, that they provide as safe an environment, that these children have a right to respect and dignity and the same rights that other children have, then I think that at the very least, the government should sit up and listen. Now, what the court has done today, and these are small gains, and I just want to also be clear that we have not gone backwards. We have gone forwards, though the steps are far smaller than our petitioners hoped for. However, queerness has been recognized. There was a lot of talk of same-sex marriage in which non-binary and trans people were being ignored. So queerness and the concomitant rights that come with being a human being of any sexuality, there is a sort of broad, abstract recognition, I think, across the board of those rights. The disagreement comes where two judges have said that the right to marry is rooted in some constitutional rights, and the other three do not agree. But all seem to agree that this is a matter of statute for various legislatures, something, of course, that the petitioners disagree with. In particular, for example, our written submissions, and we briefly touched upon these arguments, as well as Saurabh Kirpal, that Section 15 to 18 provides an entire code where sex is not even mentioned, and nothing needed to be read down, nothing needed to be read in, and just a declaration would have sufficed. However, the right of trans people, when they are of opposite chosen genders, to marry has been recognized. The right and modalities of protecting queer couples against false, illegal action by non-state actors, as well as against criminal cases, that has been recognized. There is encouragement by Justice Kaul to look at an anti-discrimination law, and that is really the need of the hour. It's extremely important.
Right. But Ms. Nandi, I'll ask you one quick question before, because we have to close the show soon. So I want to ask you, what's the way forward legally now? So, how do you proceed as a lawyer of the petitioners, and how do they proceed if they want to keep the good fight going?
Well, at the moment, really, the ball is in the court of the legislatures. And let us remember that this includes the state legislatures. The state legislatures and the Congress, the other parties that are in and out of power, the DMK, the BJD, all have, under the Constitution, powers over health, for example. So, for example, a government order or a notification can be issued to say that you must, when a queer person appoints their partner to make decisions over their health when they are incapacitated and they can't make these decisions, then the natal family that rejected them in the first place and that they haven't seen for years cannot be the people that make these decisions for them. Right. There are many things that can be done, and there are many things that can be done today.
Right.
Since the union government is speaking in a sympathetic voice, the union government can do the same. It is incumbent, I think, on all the legislatures.
But the union government, Ms. Nandi, had been of the view that homosexuality is an urban concept in any case. Having said that, I want to go back to the two petitioners, Harish Sher, Hemant Patel. Hemant Patel, with what Ms. Nandi was also stating, do you have faith in the legislature to actually, go ahead and follow, at least in spirit, what the Supreme Court asked of it?
I think as a commoner, I will have to put some trust into the legislature before, because this is a step now in their court. I will work with them like the way we did when the expert committee on transgender issues was set up in the early 2012, 2013. We are willing to work with the government to make sure that at least some of the rights within the framework of a union, a civil union or partnership, is made available to desirous couples. The rest, in terms of the next legal roadmap, will actually be determined once we speak to a larger cohort of lawyers, etc., in terms of what is it that we could do in the next step. And of course, as Karuna rightly mentioned, we will have to work with other parties in powers and state to look at if the states can step in to bring in marriage reforms or laws that can actually help LGBTIQ people enjoy the full rights of marriage equality.
Harish Sher, do you have faith in the legislature, especially with the kind of conversation that has gone down? No political party would really want to put, or at least we've seen in the recent past, put their weight behind your cause.
That's not absolutely true, though. There are some people who have put their weight around us. We have had Supriya Sule speak about it. We have had Jagdambika Pal from the BJP who has spoken. Now we have no other choice but to go to the legislatures to further our advocacy. The elections are coming, so it'll be a good time to tell them as well that you'll get our votes. We are 17% of the population. You'll get our votes only if you stand up with us.
Just 10 seconds if I can get Karuna back into this conversation. Karuna, away from, the legislature, legally, what's the way forward now?
Well, we're going to have to look at the judgment's nitty-gritties. It only came out about half an hour ago. And look at what can be done in the interstices. Look, there are various queer rights aside from marriage that have been recognized by this set of judgments. That's a place that additional work can be done. And I wouldn't say that the legislatures should be, binned en masse, right? They are, after all, democratic representatives of all our people. And the state legislatures are very important sites of these protections. And if these parties are going to say that they are a real alternative, then let them demonstrate that.
Okay, I'm running terribly out of time. I appreciate all of you for joining us. Thank you there. So, yes, we were standing at the cusp of history. We didn't quite take that leap, but does that mean we're not going to take it in the coming future? Well, I'm sure we will. It's going to be a long fight, and the petitioners will continue to fight that good fight. Thank you for joining us.